Hello guys, and welcome to another episode of my lecture. On today's episode, we'll be talking about admissions. In my previous set of videos, I discussed confession, the requirement of a valid confession, the nature of a confession. All those things have been discussed in my previous set of lectures. And I told you that my next lecture, which is this, would be on admissions. Now, what are admissions? That is what I'll be discussing in this lecture. And at this juncture, let's go to my notes. An admission is usually a statement or conduct which is adverse to the interest of the maker in respect of a fact in issue. In other words, an admission is a declaration of the truth of a fact in issue because a person will not ordinarily make a declaration against himself unless such declaration is true. Do you understand? Now, an admission is an acceptable way of proving a fact in issue which, when admitted, needs no further proof. Note that an admission is always accepted and used against its maker, that is, against the person who made the admission. Now, we have to go to section 20 of the Evidence Act. And what does section 20 of the Evidence Act tell us? It tells us that an admission is a statement, oral or documentary, which suggests an inference as to any fact in issue or relevant fact, and which is made by any of the persons and in the circumstances mentioned in these acts. Now, admission must be clear, precise, unequivocal, expressing the admitting mind of the person. An admission which bubbles on mere rhetorics, lacking exactness and firmness of purpose, does not qualify as an admission in law, as stated by Nikitobi, Justice of the Court of Appeal, as he then was in the case of Coker versus OLUFOGA. In the case of OGUNNAIKE versus OJAYEMI, Kawu, Justice of the Supreme Court, defined admission as a statement, oral or written, express or implied, which is made by a party to a civil proceeding and which is adverse to his case. It is admissible as evidence against the maker as the truth of the fact asserted in the statement. Also see the case of IMB Limited versus COMRADE Circle Company Limited. To a particular extent, we can say that, okay, we are professionals in confession. We know what a confession is. It's most likely criminal when someone admits to committing a crime and all that. Now, admission is now in a civil case. Do you understand that? Let us paint it in the light of a civil case. Note that it is not restricted to civil cases alone, but let us paint it in the light of civil cases. Now, let us imagine that there has been a battery case in tort. What is battery? Battery is when you beat somebody, or there is a physical contact between you and another person, and it must be intentional. It's part of the intentional tort. In criminal law, that would be an assault and not battery. Don't forget that they are the opposite. In tort, to beat someone is battery, while in criminal law, to beat someone is assault. So we are not coming under the criminal case, we are coming under the civil case of battery. Now let us imagine that there is Mr. A and there is Mr. B. Now Mr. A is alleging that Mr. B beats Mr. A. Do you understand? Now Mr. B is saying, no, I did not beat you, I did not even touch you, no, I did not even know you self, I don't know you from anywhere, and stuff like that. How could I have beaten you? I wasn't even there. Do you understand? This was the thing that Mr. B was saying all throughout. This is battery, you get. Now in this case, Mr. B changes his mind and no longer wants to follow the route of, oh, I have not seen you before and stuff like that. He's now saying that, yes, I beat you, yes, it's true, I beat you, but it was not intentional. Do you understand? Before, he was saying that he has not seen this person before and stuff like that. Now he has changed it. He's making an admission that is adverse to his case. When you are talking about admissions most likely has to be related to the fact in issue. The fact in issue in battery, two things: whether or not there is a physical contact between Mr. A and Mr. B, and secondly, whether or not such physical contact was intentional. Where you succeeded in both of them, without valid defense coming from the other party, then that is the tort of battery. Now, Mr. A, whose former statement was that he has never seen this person before, there's no way he could have beaten the person because he hasn't even seen or neared or anything. You get? Now, he's changing and saying, yes, I saw you and I've beaten you, but it wasn't intentional. Do you see that? That is what an admission is. An admission could come in two ways. Number one, in the initial onset, you said A. Now, you are saying B. Or, in the initial onset, you said something that is contrary to what is ought to be your position. So in a battery case, especially when you are contesting the battery, that oh no, you did not commit battery. In a battery case, civil battery case, as Mr. B's lawyer, what I should make sure that I don't admit to, or Mr. B himself doesn't admit to, is the fact that there was any beating at all. Because when I do that, it's going to be contrary to the fact in issue and it's going to be used against me. Do you understand what I'm saying? So when you're talking about admissions, like I said, they come in two folds. The first fold is where you have said one thing and now you are changing it to say another. Do you understand? Number two is where you have not said anything initially, but the first thing that you said is contrary to what ought to be your position. Those are the two things. And when you are talking about admission must be a statement which is adverse to a party in relation to the fact in issue. Do you understand? It has to be a statement or conduct or document or anything in evidence, statement, conduct or document made by a party which ordinarily is adverse to that party when you are looking at the fact in issue. That exactly is an admission. Do you understand? So let me give another example of exam malpractice. Now, somebody was caught with something in the hall, but he kept denying it. I wasn't the one with it. I'm not the one with the phone. I'm not the owner of the phone, and stuff like that and stuff like that. I said, okay, you are not the owner of the phone, no problem. We are going to sell the phone off, and the phone was, iPhone whatever that I bought for like about $1 million. Let's say iPhone 13 Pro Max XXX Plus that he bought for whatever the amount is. And now they want to sell the phone that he bought for about $1 million. They want to sell it 200,000 naira to anybody. And then all of a sudden, someone that said that is not the owner of the phone is now saying, why will you sell it for that price? Is it not too cheap? And stuff like that. And then he now later admits that he's the owner of the phone. Now, admitting that you are the owner of the phone shows that you must have been the person that took it into the exam hall in the first place. That admission would be adverse to your position that you did not commit exam malpractice. Do you understand how admission works now? Because what is the element when you want to prove exam malpractice? The fact that you must have brought something into the exam hall. Now, when the person is saying it is not my phone and all that, it then brings the presumption that this is not his phone. There is no way he would have brought another person's phone. There is a presumption, although it's rebuttable, that there is no way he would have brought another person's phone. So everybody, until further evidence is brought before the panel or the court, everybody is like, okay, it's not your phone, so he's likely innocent. And all of a sudden, somebody that was shouting that it's not my phone, now they want to sell the phone and all that. You are now coming back to say, oh, it's my phone, don't sell it, because you'll be selling it at 100,000 and I bought it for $1 million. Do you understand? And all that. Although if it's smart, he's supposed to go and meet a friend, give the friend the 100,000 and have to buy the phone and all that. But that's beside the point. But in this case, you will see that him admitting that he's the owner of the phone becomes adverse to his particular claim, and that exactly would be an admission. Do not forget that in the case of Coker versus OLUFOGA, Nikitobi said that it must not be mere rhetorics. When you're admitting something, it mustn't be mere rhetorics or something. It must be that you were clear that this thing is it. So for example, the person who brought a phone and then later said it's not his phone, and now he's coming back again to say, oh, it is his phone, he has to be clear that yes, this is my phone. He has to be unequivocal. There is no buts, because buts then brings all of that thing into the issue. So he has to be unequivocal. He has to be clear that this person wants to make this admission. So the synopsis of what we've learned so far is that when you are talking about admission, there has to be three elements. The first element is the fact that that particular admission must be in relation to the fact in issue. Not that I ate rice. Oh, sorry, I forgot. It was actually amala that I ate. In the case of malpractice, how did your rice change it to amala? How is it an admission? You just barely change your statement. There is no admission. Do you understand? So, it has to be clear that when you are talking about an admission, it is in relation to the fact in issue. Number 2, an admission can be made where that statement that you are giving, or that document that you are giving, or whatever it is that you are giving, is contrary or is adverse to your own position in relation to the fact in issue. Then that becomes an admission on your part. It is contrary to your own position. And then number 3 is that where you are talking about a contrary position, it can be made from the onset without even you having a position first then changing it. Do you understand? So for example, when you are talking about the person who brought a phone, from the onset he is saying that, oh yes, this is my phone, but I wasn't committing exam malpractice. That's it. It's my phone, I wasn't committing exam malpractice. That's one thing. Another thing is where he says, oh no, this is not my phone. Then later that changes that, oh yes, it's my phone. In both cases, there's an admission. It's just that one came later, one came first. Regardless of whether it comes later or comes first, it is an admission. So far, it is in relation to the fact in issue, and it is adverse to your own position in relation to the fact in issue. Boom, is an admission. Do you understand that? So yeah, my next class I'll be teaching types of admissions and all other things. We have admission by conduct, we have whether or not silence will be an admission, and formal admissions and all that. Those are things I will discuss in my next class. I will see you in my next class.